Hi, this is Anthony Parent of IRS Medic. Last week, we had an incredible video. We went over the statutory justification the US Treasury has for imposing FBAR filing obligations on Americans overseas and their whole penalty regime. We discovered something quite interesting, and I'm going to share my screen to show you guys what we're talking about. We are going to go to 31 USC 5314 right now. Here it is. And here's the code that we're talking about. This is the law that US Treasury claims that justifies the imposition of the filing in an FBAR. And this is what it's titled. 31 US Code 5314, Records and Reports on Foreign Financial Agency Transactions. And if you notice, the first tell is that the title itself doesn't mention anything about a foreign bank account. Rather, it discusses what a foreign financial agency is, and that a report is on there. Ultimately, and I suggest you watch our entire video, an agency is a person. And the code is very specific on defining what an agency is. And so records and reports on a foreign financial agency has to involve a person. What's interesting is the code also defines what a foreign financial institution is, where a foreign financial institution is a bank. And the code specifically doesn't require any foreign bank account reporting, as we've gone through. And lastly, in preparation for today's show, I really thought this was a great way to lead into here. And that's on this section here, Section C of the code. A person shall be required to disclose a record required to be kept under this section or under a regulation under this section only as required by law. So now, I'm going to ask a question to our resident layman, Keith Redmond, a global advocate who helps us keep us on track and tells us how reality is on the ground. Keith, you have dealt with thousands of people with FBAR filings. And here's the question I have, and you know how the penalty regime works, that people don't know about filing this. It goes to their mindset, whether they did it intentionally or not. And that could be determinative of whether or not their wealth would be ruined. That is the IRS seizing 50% or more of their entire wealth for not filing this form. So the question I have for you, Keith, is you run American Expatriates Board on Facebook. Now, if you took this code section and you copied and pasted it, but you didn't say what it was, how many people who file an FBAR would say, "Oh, that must be the legal authority for FBAR filing"? Who do you think would think that? If you read this without knowing anything, and the people that you help, if they read this, what do you think they would think this is?
That's a good question. I think they would think that maybe it won't be applicable to them to file an FBAR. You know what I mean? Now, mind you, I'm not going to go off on a tangent. There are a lot of people that just don't file the FBARs, but those that do, they're going to say, maybe I shouldn't be doing this.
Because it deals with foreign agents, not foreign institutions.
Correct.
Right? There's no author. You have to have a foreign agent is someone overseas who's doing business on your behalf. A foreign agent isn't a bank. That's a bank. And the law classifies that as a foreign institution. So now, John, we're not going to talk about penalties too much today, but don't you think it's kind of rather insane that Treasury goes and assesses willful penalties to someone not filing an FBAR? That is, okay, let's say that we live in a world where Treasury has the authority, based on this regulation that defines something entirely different, to file an FBAR. Don't you think that would provide a legal defense to any willfulness? That is, and by the way, in Section C, that says, look, we're only going to be requiring these filings as required by law. Only as required by law. It doesn't say as required by law or whatever. It says by law. Well, this is the law. Isn't that a reasonable reading that, hey, look, I went through all of the checklists of whether or not I had to file an FBAR, and I actually went down the statute and it doesn't even apply. So I intentionally didn't file an FBAR. However, FBAR penalties should not be assessed because I could not have a reasonable way of knowing that they actually would be when the form diverges so significantly from the form.
So your question is, that you're asking me to answer, is if somebody reads the statute only, 5314, and then wakes up to being assessed a willful penalty for failing to file the FBAR, the FinCEN 114, would they have a defense? Is that your question?
Yeah, I mean, that seems like the strongest defense, and it seems like a blanket defense available to everybody.
Yeah.
To say it doesn't matter because your law says not to do it. Now, look, you have your special wink, wink, secret handshakes, but you have to give fair notice to people that we're going to diverge so significantly from the law that's going to be something entirely different.
Well, here's sort of what I think on this. If, keeping the statute up on the screen, at the end of A, it says records and reports. What does it say? Sorry, can you?
Yeah, the records and
reports shall contain the following information in the way and to the extent the secretary prescribes, right? So we have a clear delegation. Okay, number one. And then, you kind of go through the thing. So my feeling is that if all somebody had in front of them was that statute and nothing else, which is difficult to read, I think it'd be almost impossible to impose a willful FBAR penalty on them because it's the statute itself absolutely positively does not make clear what is required. Now, where that might apply would be, now bear in mind, okay, that we're talking Title 31, not Title 26, and this point needs to be made again and again and again. So this FBAR rule, right, or 5314 applies irrespective of whether you're required to file a U.S. tax return. Okay, number one, applies to every, U.S. person, so to speak, in the world, whether you have to file a tax return or not. So to the extent that they try to impose a willful penalty on somebody who had never filed a U.S. tax return, had never seen anything in a U.S. tax return, but was expected to somehow, A, know about the existence of this particular section of Title 31 and be interpreted to mean, oh my God, I better report my foreign bank accounts to the US Treasury. No, I don't think that a willful penalty would be sustainable. However, there's a second group of people, and those are the people who are filing or are required to file US tax returns. And, as you know, on Schedule B, there's a question at the bottom that specifically asks people, whether they have to file, whether they have well, they now call it, I think, a bank account located outside the United States. And, that has been construed to put people on notice, right? So, I think it's a horrible thing. In my experience, very few tax professionals even could locate or identify, what the enabling statute is, 5314. It's something that's operated completely by Treasury regulations, by the forms themselves, the FinCEN instructions and that, which can change from year to year. It's a really, it's a disgusting thing.
Well, and I think maybe to really illustrate the point is really to show, let's go into this, the regulation to show the divergence, really the divergence from the law. It's incredible. And the sleight of hand that goes in there. And this is, I'm going to give you some warnings. I get really, really upset when I go through this. It's so incredibly awful. Let me get that page back up get my page back up here. Let's go to the regulation here. This is it. So this is what Treasury claims 5314 authorizes, that this is a reasonable regulation, that this is what they can do. And so they created this section, reports of foreign financial accounts. Okay, well, number one, it's like, where does that come from? We're talking about foreign financial agents. So your title isn't even right about anything. What's that related to? It's the law is foreign financial agents. So that's the first problem right out of the gate. The title's not even right. In general, each United States person having a financial interest in or signature or other authority over a bank, security, or other financial account. Whoa! whoa, where are we? In a foreign country shall report such relationship to the Commissioner of Internal Revenue for each year in which such relationship exists, and shall provide such information as shall be specified in a reporting form prescribed under 31 U.S.C. Oh boy, okay. They're saying that this is what they're saying is that the FBAR is prescribed under 315314 to be filed by such persons. And then they go further. The form prescribed under 5314 is the report of foreign bank and financial accounts TDF 90-22.1. Where does it say that? Or the successor form? It never says that. This is so fictional. There's not one thing that's true here. They're taking black and they're saying it's brown. It's the wrong color. Oh, that's our justification. Yeah. I mean, why haven't, and what is, and then they say, see paragraphs if you have more than 25 accounts. Why are we talking about accounts? Again, John, I'm going to go back to 5314. Do you see account come up anywhere in this? And wait a second, as we were discussing last week, isn't the purpose of 5314 to avoid impeding or controlling the export or import of monetary instruments and the need to avoid burdening unreasonably a person making a transaction with a foreign financial agency? The purpose of the law is that. How is filing a bank account related to your foreign agent? It's a bank account. It's not a person. Where's the relationship? I mean, this is the gall of these people, right? That is not even close to true. This is
so again. I mean, this is absolutely one of the most disgusting disclosure requirements imposed on American citizens anywhere. There's no question about it. But the reason that it's disgusting, the primary reason it's disgusting, is less the requirement to report and more, as you keep pointing out, the ambiguity and the lack of clarity in where the authority for this comes from. If you look at, if you go back for a minute to the statute, Anthony.
Okay. Go to the end of the statute? No.
Up a little bit. Okay, so it ends here, say the record report shall contain the following information in the way and to the extent the secretary prescribes. Now, as I think I made the point last week that to say that it requires that does not mean they can't ask about other things. If you can keep going down the screen on this, and let's look at the thing a little more. Now stop there. The secretary may prescribe classifications, foreign countries, they could exempt countries. Notice it says the magnitude of transactions. You see that?
Yeah.
$10,000 thing. The kind of transactions subject to or exempt. So they could, for example, exempt mutual funds or retirement funds. But then look at 5, right? Other matters the secretary considers necessary to carry out this regulation or a regulation. I mean, Anthony, it is an absolute delegation. All this section means is Congress says, you know what, we're going to make up a law, and the purpose of the law is just to delegate the Secretary of the Treasury to make up a bunch of rules to require any disclosure from anybody anytime they want under threat of penalties, right?
Actually, I'm going to disagree slightly with you because I agree that the general trend is you're absolutely correct on that there's vagueness everywhere. But this is actually a little bit different, I think, because the law actually contradicts what they're trying to do. That it's not an issue of vagueness. And I mean, there's vague things in there. But really, the law is for this, and they're taking it for that. You have the wrong thing. You guys are not reading words. Did you see the word that said the title? It said foreign financial agent. Okay, understand that word doesn't mean institution. They're two different legally defined things. So in my mind, this goes beyond just the normal regulatory abuse that we get. This goes far beyond it, where Treasury has taken a position directly opposed to what the statute is. And what are they doing with it? And this is the thing you think of. Are they doing something good with it, right? be one thing to break. Look, laws are broken for good things all the time. Weak winks and nudges happen all the time, right? So what is Treasury doing with this, right? Well, number one, we know one thing, the FBAR that is required to be filed, nothing is done with it. It's filed in Detroit, and it's a database that exists. Nothing is ever done with it other than it's open there to be hacked one day, probably like the office of the OMS hack years ago, where, hey, here's a great database of everyone who's ever worked for the government. Hey, they have your information. So when that database is hacked, eventually it will be. That's all it exists for. There's no legal, there's no law enforcement, there's nothing is ever done with it. No audits are started of it. It only exists to be filed and be there. And then what are they? And so FBAR enforcement, we could say, isn't important to anybody. It's not, because they don't do anything with it. So with that, they go, and what they do is they impose the most insane penalties ever for something they don't even do with. This is no other reason but to be vindictive and to say, oh, well, here, these people are this. And I mean, this is what is amazing. Think about this. Think about how much they don't think of you as people, but targets. That's all you are. You are a target. This is something that means nothing to them. It's like, whatever, we ruined someone's life. Well, good. We get to continue doing our stuff. And they don't even think of it. For some reason, like, well, hey, if I took a little money from you, would it hurt you? Oh, yeah, that would really bog me. But you could go steal, millions of dollars. And again, you don't have the legal justification. And all of our arguments to say this person made an innocent mistake, you're like, no. And even if it was innocent, we're going to hit him hard.
You're absolutely
right. Jane Boyd, unsuccessful plaintiff in California, she did nothing wrong, and they still assessed her $47,000 in non-willful penalties.
Yes. Well, I think that one way of looking at it would be, I tend to see FR penalties and the OVDP and OVDI programs as basically a form of civil forfeiture, right? Where,
yes, absolutely,
they just, just one way that, they can take your assets, they can take your houses. But when I look at the statute, I mean, while not disagreeing with anything that you're saying particularly, I mean, I read it in far more simple terms, which is simply that, we're going to give Treasury the authority to make up a bunch of rules, and if people don't comply, we'll confiscate their assets. That's basically what it is. And you talk about the usefulness of the FBAR. A filed FBAR has no value whatsoever.
Right.
I agree with you. But an unfiled FBAR.
Oh, there you go. Right. Yeah.
Right. If you're not in the database, an unfiled FBAR, leaves you open to, severe risk of asset confiscation at best. Okay. And at worst, there are people who've been incarcerated for failing to file a form.
That is very true.
Oh, while people are complaining about the Russian system of justice, by the way.
Right. And this is what you need to understand. The question, and by the way, and I think one more point, thank you for reminding me. And then the final the outrages upon outrages and just complete lack of humanity. And I mean, this is one of the worst episodes of government malfeasance. It's up there with, not quite up there with intentionally poisoning 10,000 people with poisonous alcohol and prohibition. It's up there, though. I mean, who knows? Maybe. I mean, this is just beyond. This is not going to look good. Because here's the one more thing that they do. The people who raise their hand first to say, oh, I made a mistake. I want to come clean. Let me show you everything I'm doing. Those are the people they hit the hardest and the worst. They unloaded on them the most because they have no game, really, because they can't go after anybody good. So the people who they have all feared, and they go, okay, here, they got them, and they put the fear of God of them with those FBAR penalties and extorted them into disclosing everything and to being raked over the coals. We have people going 8, 9, 10 years on this process. For reform, they don't even
still involved in the OVDI programs.
Well, I still have a few opt-outs still going on, and the absolute insanity of this, it's so beyond. It's a lawless government that we have, because this is the question. And if you disagree with me, fine. But this is the question I'll ask you in return. If our government was controlled by a cabal of our enemies, how would it be different?
Might be more humane.
Yeah, that's kind of like they would be better at PR.
Yeah,
like Al Capone was better at PR. That's what it had. That's how if your enemy would actually be a little bit better to us. Because, well, I mean, this is, I'll tell you, Vladimir Putin is not my threat. He is not the one destroying my life. He's not the one destroying my client's life over a form documenting the fact they did nothing wrong. Over a form the law doesn't even require to be filed. He's not the one. He's not the one destroying them. He's not the one committing financial terrorism, claiming, oh, we're going to put you in jail. You're going to put someone in jail. You threaten to put someone in jail because they didn't file a form you don't even have the legal basis to require. That's where we are.
Let's say
what is worse than this?
Well, let's say that, I mean, I think that there can be reasonable disagreement on whether there's a legal basis to file the form or not. So let's just assume there is a basis for the requirement to file the form. Okay, with or without the requirement. Okay, this is one of the most draconian and inhumane things imaginable. In fact, Russia in the last 10 years or so adopted their own version of FBAR, and do you know what they modeled it on?
What's that?
Yes. Same thing. US Treasury. Yeah, absolutely.
Oh.
So, you know, I think when the history of the United States is written, I think there's very likely to be a chapter on Mr. FBAR and the role that it played.
Yeah, the problem with this story is it only affects very few people, so it can't, doesn't really do it. But this is why I think, look at what they're doing. If they could define foreign financial agency to mean foreign bank, why can't they define it just to mean bank? Why can't they define it to mean anything? That is, oh, you didn't file your FBAR for your credit union you had in Vermont or something? Oh, well, you didn't know? Well, we've decided that, Vermont is foreign to you because you live in Connecticut. So yeah, why not? There's nothing to stop.
Absolutely right. I mean, if we look at the, either the statute or the regs or whatever, I mean, I think that's absolutely right. And on this point, I'll make this point as many times as I can. People need to remember that this is Title 31, not Title 26. So there are different definitions of things that are applying. But Anthony, you're upset about this, and I agree. You're visibly upset about it. But
absolutely.
Don't you realize that this is the modus operandi of the U.S. government? I mean, it's as though you're discovering this.
Oh, thank you. Because we're working on a terrible case, and one of my star ruled agents, Suzanne in Arizona, sent me over a link. She watched the podcast last. She's you're a little nuts here, Anthony, but I like your passion, is what she said. But then she also sent me a follow-up link, and I want to share it with you guys because this is not an isolated incident at all. Oh, no. And it's not an isolated incident only to bank secrecy things. Oh, no, at all. And this was a great article. I want to show you guys. Suzanne shared this to me, and this is written by some, they seem to really know their stuff here. This is on Miller Canfield. This is an incredible case. I'll put this in the link article. The authors here discuss 3 different instances in which administrative guidance, all this regulatory stuff, the IRS is like, yeah, no, we're not going to do that. We're just going to do what we want to do. And actually, in every case, the IRS just did whatever they wanted to do. And it's just absolutely infuriating. Some of these cases, one of them involves someone setting up a CFC to specifically avoid a base tax inclusion, and they did it according to the Rev Proc. They're like, yeah, after you did all that work, no, we're not going to let you do it. And I'm just like, I could see that tax professional just blowing up. I just had my client jump through all these hoops so they could pay all this in taxes according to your game plan. And you're saying it's wrong. And so, I mean, they are just making it up left and right all over the place. And then I guess this is my hope that they're doing this so bad everywhere. I mean, throughout the law. And again, not limited to Treasury. This is, what EPA, all of these government they're all making up their own law. And I think that is what we hopefully have proven today. They are making this up.
It seems fairly clear to me, and I'm sure that you would agree, that taxpayers or, FBAR subjectees or whatever, have a right to understand what's required of them, right? Wouldn't you think?
I would think so, right.
And this is leaving aside, the propriety, the reasonableness of the requirement at all. The bigger problem that dwarfs all else is that this stuff is so difficult to understand. You go online, you'll find, all kinds of articles from, lawyers not so much contradicting each other, but not really in alignment, on a lot of these issues. And this punishes the people who really, really want to be in compliance, because what they do is they fall into this culture of, well, I don't know, if this is caught by the law or not, but I better fill out the form anyway, in case it is. I mean, think about the whole 3528 penalty fundraiser a few years ago, and then they just get assessed penalties. So the substance of the laws is one issue, but an even bigger part of the problem is that nobody can understand what the damn laws say.
Isn't that truth?
So it's like the definition of an American citizen is a carbon life form with a sword of Damocles hanging over his head every second, just waiting for somebody to pay attention and say, "Good morning. What law have you violated today?"
We are right. And again, the FBAR is not the only one. I mean, it's just out of control. And, this is, that we can't be so, myopic and think that the problem is just, Treasury. It's all out. Now, I want to conclude today with a question of the layman of laymen, Keith Redmond.
Another title,
my friend, you have been with us for years. And you have gone and you these laws, you have gone through our analysis and you've been at the hearings and everything. And so now, do you think it's even possible for an American overseas or an expat, or actually even any American, to actually ever know if they're in compliance with the tax law?
No.
So when we
it's extremely difficult. On each return, everybody has to sign a tax return saying that they fully understand understand the law and their facts. They fully understand that they're certifying it's the best of their ability. Is that correct? Yes.
And so the question is, how could you certify to the best of the ability when there is no law? That is, we don't know. The IRS doesn't know what the law is. So how can we be expected to know what the law is? And if no one knows what the law is, how could anyone agree that anything is anything?
I think that the certification, Anthony, has, evolved into something more like this. I certify I'm not willfully breaking any laws. I think that's all it is. I certify I'm not willfully breaking any laws. Now, a second thing, though, is, you ask the question, how can you know you're in compliance? There's only, as far as I can see, one group of U.S. taxpayers who can say with absolute certainty they're in compliance with the U.S. tax laws, and those are the ones who don't meet thresholds to be required to file a return, and they don't have any independent information return requirements like 3520s or 5471s, which require filing. That's it. Everybody else, it's just open season.
There you go. It's open season with
your numbers up. Your numbers
wide open laws. These are wide open laws. All right. So next week.
Actually, Anthony, before we go next week,
I want to tease next week. What do we want to? What do you want to close with, guys? Let me give you
tease next week. Why don't we go back to the regulations?
Oh yeah.
Real quickly, what they
absolutely. All right, let me get my screen up here.
Because this is where the rubber hits the road.
All right. Okay. Here we go.
This is
Okay.
once people.
All
know
right. So this.
this,
All right. Here we go. All right. Here we
it's
go.
like
Here's
what happened in the Garden of Eden. It's the forbidden fruit.
there
So
it is.
everybody,
All right.
here comes the forbidden fruit. Once you know about this, you're in trouble.
Uh-huh. Okay.
Okay, I'll just give a bit of commentary as we go through this. Okay.
Okay.
Now, so it applies to United States persons, and B, that's a citizen and a resident. Okay, now notice again, though, you have to modify the definition of resident a bit. It would include resident alien under 267701B, meaning a green card holder, okay, or a substantial presence test, and there's some more stuff. Now, one of the issues there, green card holder takes a tie break position, who's not a long-term resident, still under their interpretation of this required to file an FBAR. So you may want to keep that in mind. You can run, but you can't hide. Just continue going down here. See reportable accounts, bank securities, other financial account. Look at all this stuff. I mean, anything at all, right?
Yeah, and even though, and again, just to tie together what the true outrage is, all this financial account stuff. This is not what 5314 asks for. None of it is what it asks for or requires. This is specifically, it wants agent information, not bank information, specifically defined.
It's the authority to, it's, as I say, to do whatever they want. But you'll notice how this is so broad that I think that the way people should read C is don't read it. Just substitute the following message from the U.S. government: report early, report often, report everything, and keep a record of what you report. That's what it means.
Yeah.
Then we'll go down. As always, there's carve-outs, right? Now, I want you to notice,
of course.
And we've talked about this before. The general approach to this legislation is everybody has to do it with exception, right? Not you have to do it if, but everybody has to if exception. So notice here they've carved out a bunch of exceptions, et cetera. So continue on down. Foreign country, there you go. Outside the United States, but notice how, again, they're referring you to a specific regulation to find that. Financial interest. Okay, if you have signing authority, you're covered, plus beneficial ownership. Continue going down. Okay, this next part basically describes situations where you may have to file an FBAR, for example, if you're a shareholder of a corporation, et cetera. I mean, that stuff gets pretty complicated, but I think it's important to know that it's there.
Oh, wait a second. Here we go. Because it's like, well, I think this is close to what the law actually authorizes. Even though it's not quite, I mean, part of it is, but they kind of mangle it all over the place. But a person acting as an agent, nominee, attorney, or in some other capacity on behalf of the United States person with respect to the account. I could see the argument if that was worded, that's somewhat tied, but it's not. I mean, that's there, but it's not quite what the law would require, because the law says when you are acting, when you're acting as an agent, when you are acting as an agent for someone with a foreign financial agent who's acting for that person, that's when an FBAR is required. 3 people in order for an FBAR to be required. That is somewhat tied to it, but everything else is just sort of, fantasy land. It's not there.
I'll continue going down. Signature, other authority. All you have to do is have signing authority. I mean, this stuff is so expansive. It probably even covers, if you're able to use somebody's bank card, to get access to their account.
Right. And signature authority is a huge, just because you have signature authority doesn't necessarily mean all that much unless you want to go to prison. Many times.
Well, if you have signature authority, you have to report it. But if you don't have signature authority, that doesn't mean you don't have to report it. Okay.
Right. Yes.
So,
but
the point is simply this: that it's there. Those are the basic rules. It's basically a presumption of everything reportable, with various.
Yeah, that's what we, and that's what we've always done, and I think this has always been, this is what really has been making tax law, everything so miserable, more and more miserable each year. There is less and less law to rely on. Nothing means anything. And, and I think that, the link I showed earlier, practitioners around, people around the world don't know what to advise your client on. It's like, well, I could advise you what the law is. I could advise you what the IRS thinks it is. I can advise you what the courts think it is. And then I could advise you of the only way to fix it is a political solution when all these turkeys get voted out, and and some people will have to face trial for the crimes that they've committed.
So I think that for our next podcast, we also need to talk about some real world issues, because I've dealt with people who have signature authority over their company's account, and their company has nothing to do with the United States.
Yep.
And they do not have permission from that company to divulge anything to the IRS or do an FBAR. They do not have permission to do it.
Oh, you know what? Does that? Keith, okay,
that's just one of many examples.
Oh, I'm glad I paused on the tease for next week, because I think I got what we're going to do. I'd really like to go over some FBAR penalty examples next week, and the other thing that exists that I found, little gem, in Title 31 is the Privacy Act. Your penalty of that individual made me think about, does the Privacy Act of 1978 apply to FBAR data collection? Let's see if we can figure out the answer to that as we discuss some of the terrible FBAR penalty cases, Keith, that, tell us, give us, and maybe if you want to get a post up on American Expatriates, just to get some of the worst stories up there. So we can sort of maybe find some ways to say, here's some ways to look at it, maybe some solutions or arguments to hope and fire people up to get the Supreme Court really on our side for Bittner, which, I think with EPA out there, it's real promising that some sort of reel back of the FBAR penalties is going to happen. But honestly, the entire thing needs to go away because there's no justification for it. And so that's really the move that we're hoping the Supreme Court makes. And all of these penalties that have been terrorizing people for no reason at all, but just to terrorize them, will be reversed.
I just had an idea, Anthony. There's this new Inflation Reduction Act, they're voting on this week. And do you think there would be time to get on a last minute a section authorizing or actually requiring Treasury to build an FBAR museum?
How many jobs do you think? How many green jobs do you think it's going to make?
Program, right, where they could have different rooms, the evolution of FBAR over the years. They could have pictures of people's lives being destroyed,
and it could be on the mall.
It could become a tourist attraction. People who are in DC, the first thing.
Well, you know what? And I kind of see it more of a franchise operation. And here's why: because people need to have that tactile, immersive experience locally. And you're trying now. I'm just thinking outside the box here. One place that is pretty much unused right now is any U.S. Court of Justice. So I think they're not using it. So we could put our FBAR museums right there. They're all an easy to locate.
I think that's a brilliant idea. I think when you walk into a federal court, there ought to be an immediate room, which is sort of one dedicated to each form, right? 5471 penalties, FBAR penalties, 35. This would be perfect, and it could double as an educational, school children.
Exactly. And the marshals and the guards there, they'll be so happy and polite to you, and they'll say, we have no idea what any of it means either. They'll be there. We don't know. All the tour guides will all be saying the same thing. Yeah, we can't figure it out. But we can tell you this, it's not looking good for you. So let's go.
I think that there's a message here, and it's kind of like this. All roads lead to renunciation.
Oh, man. Or something. Or all roads lead to something else. If it's not that, some people will be renouncing things. It's not looking good. I think people are getting really fed up with this, and that we are ruled. We are completely overruled by people who break the law for no other purpose. They're not helping anything. This isn't for any legitimate purpose. This is just because they have the power. I mean, it just from the outside, it looks like people who are weak, who have nothing, and they've taken their authority that they have from their position, and they're using that to find their importance in life because they must not have any. Because if you do this, well, first of all, no one in the private sector is really looking for you, right? You're really not there. So if you're doing this, you are the lowest life out there. If you are doing this, if you are on that side and you're saying, yeah, these FBAR penalties are a good idea, you are the lowest form of life. And I think you need to know that. So we'll see what happens. If your rule is going to be upheld or if people are going to, I don't know. We'll see. I mean, I don't know. Maybe people won't rise up. I don't know. We haven't yet, but this is pretty out there, right? And I think, you know what? And if you don't agree, and I think right now people say, Anthony, you're getting a little crazy. But next week, we'll show that maybe I'm not crazy enough, right? So join us next week as we talk FBAR penalties and some of the possible solutions to this completely illegal government that wants to destroy you. This is Anthony Parent for Keith Redmond and John Richardson. Thanks so much for joining us today.